Part 1, Section 4 and 5. In this section, we will review the rules of professional conduct that apply to you in your role as a guardian ad litem. In particular, we will be looking at your relationship with your client, the boundaries you must respect in terms of confidentiality and privilege, your responsibilities as an attorney in terms of commitment, the expectation of competence, possible conflicts of interest, and appropriate communication. Each of these concepts functions as an important ethical obligation you must remember in the representation of your client. First, as a GAL in Wyoming, you must understand that there is the presumption of a normal attorney-client relationship. By the very nature of having a GAL appointed, the child becomes a client with diminished capacity under the rules of professional conduct. That said, you should make every effort to maintain a normal attorney-client relationship when at all possible. This not only ensures that the client trusts you, but it also protects you as the attorney. Next, know the boundaries of confidentiality and privilege. In some situations, this can mean not sharing confidential information that is attorney-client privileged. When you are meeting one-on-one with your client, everything your client shares with you should be considered confidential and privileged information. There may be times when you learn something that is a safety concern, or when it is in the child's best interest that the privileged information be shared with a DFS worker or the multidisciplinary team. When this occurs, you should make an attempt to get permission from your client to share the information. Another avenue to pursue would be to get the information from another source, so that you are not revealing confidential information that your client has shared with you. Treat your child client as you would any other adult client you work with. If privileged information needs to be shared, you can explore the normal expectations to the confidentiality rules. As you practice law each day, you should keep in mind that first and foremost you are the client's attorney. The rules of professional conduct require that. A lawyer must also act with commitment and dedication to the interests of the client and with zeal in advocacy upon the client's behalf. Fundamental to this is the understanding that it is in the best interests of every child to remain with his family if possible, and if he must be removed, to return home as quickly as possible. Only in cases where the child is unable to return home should the GAL look to permanency options outside of his home. As a GAL, you are responsible for providing competent and ethical representation for your client. This includes competence in the law, but also a level of competence in stages of child development, services that are available in the community, and motions practice. Ensuring you are able to determine your client's best interests requires that you have a thorough and detailed knowledge of not only her case, but also the state and federal statutes regarding juvenile court. To ensure this level of knowledge, read and review Title 14 of the Wyoming statutes at every opportunity. In much the same way that you would pull a favorite book off the shelf to reread and enjoy, you should read and reread Title 14 constantly. Having an intimate knowledge and understanding of the law is in the best interest of your client in the juvenile justice system. It will guide you to operate according to state statute and to progress according to the timelines required. Other relevant statutes, rules, and policies are covered in Sections 6 and 7 in the handbook and will be covered in future modules. Your job as a GAL is to advocate in the juvenile court process on behalf of your client. You are there to ensure that the process operates pursuant to state statutes. Whenever necessary, you must undertake motion practice to insist that it does. Always remember you are working to assure the best interests of a child. Pursue them zealously and passionately. As we have just discussed, it is critical that a GAL be competent. However, this does not mean that you need to be an expert in child development. You do need to be familiar with your community partners, services that are available, and the needs of your client. You need to be able to ask the right questions of the right people and to insist that these services are provided. Although this may seem like an overwhelming expectation, there are many high-quality trainings, conferences, and materials available to Wyoming GALs. If you make the effort to take advantage of these training and informational opportunities, you will have the knowledge you need to competently represent your client. You need to be familiar with motions practice in your local juvenile court system in order to move cases through the court system expeditiously. Keep in mind that your knowledge of the law and child development means nothing if you simply sit back and wait for others to act. Always remember that it is your duty as a GAL to act with commitment and dedication to the interests of your client. The expectation of a guardian ad litem is nothing less than zealous representation when advocating on a client's behalf. There may be times during your GAL representation where a conflict of interest can arise. For example, when you are representing siblings. Conflicts of interest are governed by the rules of professional conduct and also by the program policy on conflicts of interest. Representing siblings is not automatically a conflict, but you must be aware that one can arise at the beginning, the middle, or at the end of a case. You must watch for this, and if a conflict does arise, you need to ask the judge to appoint an additional GAL to represent the other sibling or siblings. You must also ensure you do not have any confidential information from the sibling you will no longer be representing that may harm that client. If this happens, you should remove yourself completely from the case. A situation that may result in a conflict between siblings is when they have differences of opinion as to the outcome of the case, where one's desired outcome would detrimentally affect the other sibling. In general, as an attorney, you know that a client can waive a conflict of interest. However, since the child is considered a diminished capacity client, you need to consider whether or not he or she can make an informed decision about the conflict in order to waive it. You should make every effort to avoid this situation, since it is often unlikely that a child could truly understand the problem and the legal consequences of the waiver. Avoiding this situation protects you as the attorney. The last ethical obligation we will discuss in this section has to do with appropriate communication. You must be aware of the legal and ethical rules surrounding your communications with represented parties, such as parents or the Wyoming Department of Family Services. The most important thing to remember when dealing with and talking to other parties in the case is to ensure that, if they are represented by an attorney, you get permission from their attorney to speak to them or have their attorney present. This is especially important with the parents on the case. If an attorney represents the parents, be sure you get approval from their attorney before you talk to the parents about the case. Further, you represent the child, and therefore opposing counsel should not talk to the child without first obtaining your permission. Being aware of and abiding by the ethical obligations and issues surrounding your duties as a guardian ad litem will help you appropriately navigate the legal system and ensure the best interests of your clients. Keep them in the front of your mind each time you begin work with a new client, and review them periodically as you work with each of your existing clients' cases. Now we will move to Section 5, Communicating and Interviewing Your Client. Establishing a relationship of trust and honesty and building rapport with your client to help him feel comfortable with you is essential in truly understanding your client's needs and determining his best interests. In this section, we will provide you with a pathway to building rapport and tips regarding how to question and interview your client in a way that is both age-appropriate and effective. Finally, we will discuss the importance of the boundaries that you must observe when working with your child client. Developing a rapport with your client is one of the most important steps for a guardian ad litem. You must develop a relationship with the child based on trust and honesty. Oftentimes, children have no idea what is going on and they are in crisis. In the first few days of a case opening, the child has met with many new people and may have a difficult time understanding each person's role. The age or development of your client is the most important factor when developing rapport with them and will drive the relationship moving forward. How you communicate your role, your questions, and necessary information will differ greatly if the child is 3 versus if the child is a teenager. When you first meet your child, it is typically in a setting that is foreign to her. For many children, this can be uncomfortable under the best of circumstances. It is your job to assess the comfort level of the child in order to gauge what the first meeting should look like. It is very common for the first meeting to be brief, informal, and to occur in the child's current placement. The child may wish to have his foster parent or relative sit in on this first meeting. As you begin to get to know the client, the next meeting may be in your office or outside of the placement, and you can begin to meet with her alone. You should introduce yourself to the child and tell her that you are his guardian ad litem. Depending on the age of the child, you can go into more or less detail about your role. If the child is too young, or if he cannot or will not engage in conversation, it is your job to observe the child in the placement, assess any developmental delays or behavior problems, and generally be around him to assess and investigate the case. Explaining your role as GAL to your client depends largely on his age. With a very young client, you may not be able to explain your role. With older children, usually between the ages of 3 to teenagers, however, you must tell them what it is that you do. It is your job as the GAL to explain, in age-appropriate language, what type of GAL you are in the case and what you are responsible for doing. Be sure that you explain to the child what information will be kept confidential and what won't. Reporting of abuse and neglect is mandatory and cannot be kept confidential. You should also explain to your client that although you and the child share a certain level of confidentiality, there may be things that you will need to share with a multidisciplinary team or court when you believe it is in his best interest to do so. You should explain to your client that you will avoid sharing any information you have obtained from him, but in the event that you must share the information, you will consult with him prior to doing so. Keep in mind that if you can possibly obtain the same information from another source, you should make every effort to do so. This will help to preserve the confidentiality and trust you have established with your client. Be sure to talk about what happens if you and your client don't agree on how his case should be resolved. If you and your client agree as to what is in his best interests, this is what you will tell the court. If you and your client do not agree as to what is in his or her best interests, you must inform the court of your determination of the client's best interests and what your client believes to be in his or her best interests. It is very important that your clients understand that they have a voice, but that you as their guardian ad litem may also make a recommendation that is different from what they want. This is a very important step that helps to establish and maintain trust. When meeting with and interviewing your client, first consider whether he or she is safe. Typically, if a child has been removed from his home, he is either in relative care or foster care, so he is no longer in danger. However, it is the GAL's job to continue to monitor the safety of the child regardless of the current placement. Remember, though, that it is also important for the child to feel safe. The type of questions you will ask your client will vary depending upon his or her age. It is inappropriate to ask a very young child where she wants to live, especially at a time when she has just been removed from her family. However, an older client may have an opinion on this issue that you should know about. So if it is age-appropriate to do so, you can ask your client if she wishes to remain in her current placement or if there is another placement in which she might feel more comfortable. It is important for children to have some semblance of a normal life, and oftentimes where they are placed is the first step toward this normalcy. Always attempt to ask open-ended questions and avoid suggestiveness when speaking with your child client. As you build a relationship with your client and she begins to be more comfortable with you, she will be more likely to give you detailed and accurate information about what her life was like before and during the incident. Your questions can then become more specific and personal regarding the actual abuse or neglect incident that brought her into care. If the child has worked with a therapist or if she has shared information with another reliable adult, often you can use information from one of these sources to fill in the blanks of your investigation. It is crucial that as a GAL you conduct your own independent investigation aside from information gleaned from the child. Use all available sources such as school records, school personnel, family, friends, neighbors, medical personnel, medical records, church members, and any other sources having a connection with the child. But be careful. It is important that you maintain confidentiality surrounding your client in the case as possible, so approach these people with caution and care, and do not share information about the case with non-parties. Don't assume that they know what is happening with the child's case, and do not trade information. Being a GAL is a very difficult, yet extremely rewarding job. The children you will come into contact with can easily become very personal to you. It is your job as their guardian ad litem to represent to the court and other parties involved in the case what is in their best interest and to do whatever is necessary legally to progress towards this goal. On the other hand, it is not your job to become the child's parent, therapist, teacher, or friend. The child already has people in his life to fulfill these roles, and it is very important for him to build upon these natural supports and not rely on you. Defining your role as a GAL is often easier said than done, so it is extremely important that you define your role both verbally and with your actions from the very beginning. If a child comes to you with a question or issue that goes beyond your role as his attorney, you should refer him to the appropriate person for assistance. This may be a social worker from the Department of Family Services, his therapist, a foster parent, or another professional. As a guardian ad litem, you should not offer gifts or services or advice outside of your level of expertise. This can be very difficult, especially when you have developed a close relationship with the child. Most often, the best help you can give is connecting the child with someone who can provide him with the necessary help or advice. The GAL program policy provides information and examples of things you should not do as a GAL, as well as actions that can be considered a red flag for future problems. To ensure that you are staying within the established boundaries of a guardian ad litem, take the time to make yourself familiar with program policies. Here are a few red flags to watch for that may signal that you have crossed a boundary and should contact the GAL administrator immediately for help. 1. Excessively thinking about a client away from work. 2. Planning other clients' meetings and representation around a particular client's needs. 3. Being defensive about your representation of a client. 4. Secretive behavior with a client. 5. Giving gifts to the client or their family. 6. Inability to remain objective to feedback or comments from the team due to strong feelings for a client. 7. Feeling personally responsible for the client's progress. 8. Feeling possessive about a client. 9. Believing that the system does not understand the client the way that you do, and believing that because of this you must personally intervene. 10. Believing that colleagues do not understand when you discuss or defend your behavior with a client. And 11. Considering yourself part of a client's family. At all times, when communicating with your client, you will be most successful if you take the time to build rapport with him before digging into the hard, personal questions. Be sure you explain your role in a way he can understand. Use open-ended questions whenever possible, and be careful not to put words into your client's mouth. Define and maintain clear boundaries in your client-GAL relationship. Your efforts will yield results in both the quality of information gathered from the child and in establishing a bond of trust with your client.